So latest update on Chairman Wontumi's ne illegal mining case. Na busua sa update we ye best frame Endra and asa update we e ba yenya technical issue bi ntino ye ntumi amba me drop e de amamo ene Chairman Wontumi e kwa akopie mu e wo court bet ye pese edi kan breaki sa update we ansana ye de ene latest update in court live ye be drop na ha ede amam abusia sa plan a Chairman Wontumi ni lawyer no omo a plan ni new lawyer ye friend AttaAkyea no lawyer AttaAkyea ye se court no onkopie mu ene tie according to Kevin Taylor ni poster the babonten no Samuel AttaAkyea as Chairman Wontumi ni new lawyer no ye se onkopie mu e wo court o dwane ana se o free Ghana ha say o che se o yare pa ya jena to hospital ewo se abroad na that means oni Ghana ha say se oni ye jurisdiction mu and lawyer yi asan so aka Chairman Wontumi say any court case na be koso ndi kwan Chairman Wontumi enso kokopie mu o court ono nso enka se oyare na se case no yemfa nto baby judgement na yemfa nto baby abutua eno ene ya project de AttaAkyea screen no enchen the amount of credits goes to Kevin Taylor ono and a break it update to my say breaking news Samuel AttaAkyea lawyer for Bernard Enchibu-Siako, popularly known as Chairman Wontumi, reportedly does not intend to appear in court tomorrow for delivery of the final judgment in the Republic versus Chairman Wontumi. According to our insider, AttaAkyea plan is to claim that he is seriously sick and has been admitted in a hospital outside Ghana, hence he cannot appear in court. We are further informed that he has also instructed his client, Chairman Wontumi, not to appear in court either, so they can both claim to be sick and admitted to hospital at the same time. The trial judge has scheduled Monday, which is 20th July 26, for the delivery of the final judgment. These are the latest shenanigans Wontumi and his legal team have planned for tomorrow. Attached is a letter they wrote to the judge 2 days ago asking the judgment to be postponed for second time just to delay final verdict. In Tebusuya Asemno and a dahon. The entire breaky sa news we know. Ye person what story na see ye and kasa course and the story na ye baby breaking no. A Chairman Wontumi in the story into click on the notification bell to send about any update be about dropping on so once able to me. I can be able to answer never calling Ghana ha. So open computer papa and a laptop papa now we're using a Buria computers and accessories and I'll be a laptop papa now we're using the location and you're quite old Kumasi Bokrom Estates Eli Frey number na egu screen ase abusia yembon Ryan se me bayade dia akabeto amso
former MP for Tamale Central yene ne ntwenko Alhaji assalamu alaikum Alhaji assalamu alaikum ba modern se saraka yen saraka Alhaji ne yene ne din komo boye nana yenko nana Christopher mo nana ha musi muntwa loto
yeah
na American lottery
nana ajala disi DJ yombo ba ya ne yesa argument you say na lottery no e dia boss ya no this way
and they will go bridge wa we dey overtna okay Alhaji honorable Inusa Fuseni me mo acha no pay boko na also Alhaji when you mami lay this promise ne family enkomo aye ben yewa chama Wontumi oman no ebo ne kwadu ye de ho asem e ba court ye de ba court no ye be ye ya de ne charges nyina kire no Emma afe case management crash asie ye bubo mu from case management stage noa ede by safe ya hyase nie na se prosecution friend and witnesses ni nyina ansa na no walidi wonoa ayi chese ede aba nipa bi wo wa ye mu prosecution witnesses wo mu nyina by defense no so wo mu file say submission of no case ekoye court to say there be you have a case to answer but I never answer wo baaye ekofre na dance for wo mu bo anu am obi a close ni case ekodu baby a afei judge no a date for judgment and now was shared the accused and the prosecution say wo mo file wo mo addresses yanto akwa ankoso anso yete ya lawyer for Chama Wontumi say oh okay mayi me wafiri mu niam bi wo a na enye fair throughout the trial no and na yeru AttaAkyea obeso mu no he prayed to the court to say omo ma ne break kakra na won fan file address afi na waba enua was the deadline on or before 13th of this month enua no wa file address ne de aba address ne ba ko awu mu pa ne say he is asking the court to stay the judgment. Na ehon na me person no di nkomo efa as a lawyer e dia na woni ye beche by way of education and thoughts.
It is within the right of counsel AttaAkyea to pray the court to suspend or hold the delivery of judgment AttaAkyea to win Kasa. But the thing is, he must adduce cogent evidence. So, AttaAkyea Okasano is so fundamental that it can affect the delivery of justice. That will also be contained in the address. Okay, you must give the court an indication of why he thinks, sir, the court should stay judgment. Because you can't pray the court on nothing. And an empty sack cannot stand straight.
Baba, court will be an empty what?
An empty sack cannot stand straight.
Okay, just a what are we in Munu? Entimi nyina brane, entimi nyina ho. Just a bibi wo. No, what shall I say? Hey.
But your stay judgment. Let me say me call Supreme Court and call interpretation of a provision in the Minerals and Mining Act. That's all. You can't say that. You must build your case and convince the court says staying judgment will be in the interest of justice. You must build the case. One can say the Supreme Court will rule in your favor. But AttaAkyea Emma will say court and staying the judgment and then say there must be something, there must be a premise, and it must be so fundamental in your view that you think it can affect the delivery of justice. I mean,
Mami Musa question be wa dey be a conversation is he seeking on behalf of his client to arrest the judgment?
That's an arrest of the judgment. That's another way.
Mebo, baby, I yet draw ye war any precedence in law. Say, baby, I yet draw ya judgment is set to be delivered. Now, Obia Kose, me ye, na Minerals Act, na dear be one more. Now, we're not just it amounts to say ye open case, you be one.
No. Yes, I amounted to the matter where a court is sitting on. Even this Asin Fosu matter was it's a precedent in that matter.
Okay.
Whether or not a person who files for the renunciation of citizenship and files to contest an election before a certificate of renunciation is issued is otherwise qualified to contest the election without the certificate of a renunciation. What does the constitutional provision actually mean? So that was an interpretation. The one was the High Court in second year or so had to stay the judgment. I mean, had to stay proceedings for the matter to be escalated to the Supreme Court for determination. So it happens as a precedent. Even in this case, even in this particular case, Wontumi case, and the AttaAkyea Kube na Kaniano or a lawyer. Now, and the AttaAkyea Kube did not raise this matter. So again, it will immediately bring into your mind the case of Nimaka, not Nimaka, Panda Empino, design. Indam. Not lawyer, the all year in Indam case in Panda, no, Tamale. Sa lawyer, no, on the almost a courtroom judgment, no, or appeal against the judgment. But Nindam Ebi file no buy ever Garenimako. Garenimako said, appeal. This matter is not a matter of appeal. It's a matter of judicial review. Because court no and need to me to sit on the matter in the first place. So we will abandon the appeal and go to the Supreme Court. Of course, Supreme Court no, the court agreed with him. So again, in the Wontumi case, and the AttaAkyea Kube did not see anything wrong with the Minerals and Mining Act under which we Wontumi and Jurisdictional and his company were charged. But AttaAkyea is seeing something. But it's not the seeing, it's the conviction that what he is seeing is actually tangential to the delivery of justice. I'm making myself clear.
Yeah, clear.
Because courts be every day, every day we interpret the Constitution to guide our activities. Courts be has interpretative powers of the Constitution, but where in the implementation of the Constitution, they interpret the Constitution. But where there is an issue of interpretation, then that issue is within the exclusive jurisdiction of the Supreme Court.
Hey, counsel. So, lawyer for the defense, Wakani, is the court bound by it? Say, Wontumi and Koswara and for judgment in come 20th of this month. Name Jisabia or train for the constitutional interpretation as the defense counsel.
This one is a statutory interpretation. It's a statutory interpretation. It's not a constitutional or say statute no or Minerals and Mining Act no. There's a problem of interpretation on that. Okay? And then I mean can say every court interprets the statute. Okay? But where there is an issue of what it means, you can escalate it to the Supreme Court.
So, in case of this, why not we bet me a stop court and say, don't deliver judgment. You arrest the judgment. Wait until say be a Supreme Court. The other battery anymore. You be come once a week.
It's a prayer. A prayer.
And koto sere na wo sere.
sorry, God can decide to answer our prayers or not answer. You can, it's not bound.
Court no pa, obejatum, opa onyintum.
That's all.
It is just when I walk and onye na dwene se bia he's seeking say ye open case na niam bi wo a e bia okeka na won addresses ni mu no ye dealing with it.
Oh, court no but and if you think that my understanding of the law is wrong, that my judgment does not prevent you from seeking release at the Court of Appeal or the Supreme Court. Court number because
council the prayer no what the adie bi ka ho 13.3 or say alternatively, should this honorable court decline the request for constitutional reference to hold that the Republic has failed to prove beyond reasonable doubt the essential ingredients of the offences charged against accused person 1 and the accused 3 in counts 1, 3 in counts 1, 3 and 4. Bueno, na opeso kire se se court no anye saa e bia niam bi wo wa ankoyi a there will be travesty of justice ana.
No. So even that prayer, the second prayer, no, defeats the first prayer.
Oh, sir. When you change kakray?
Because you see, second prayer, no, say offense, bia et say we unquine bia wo the ingredients. So what the abe edit fra krakra you can call it krakra krakra
101.5.
okay Wontumi and I would be why again antuma yambuno. So every offense has ingredients. So you must establish those in the ingredients beyond reasonable doubt. You must establish that the accused person has committed that offense. And why you say the accused person has committed that offense is that the ingredients of the offense are A, B, C. And the accused person has done them. And you show by evidence, say, why, yes, I did. And show, even in cross-examination, I did the kind. You will show that. Once the man tried by the ingredients, then you have not established the offense. So if you are praying alternative, the prosecution has not been able to establish the guilt beyond reasonable doubt, because once the man establishes the ingredients, then that prayer is an appealable prayer. It's not interpretation.
Oh, it's an appealable prayer. Oh, now wait, you're funny. You knew the judgment in the 20th of this month. And this ekobasi year. Avenue Ben, Emma, Sabian Fancy, and Kwama, the accused now, and Kwama the defense now. Avenue Ben, Edema Womubu.
Oh, so the process, you escalate the matter, either on appeal, or you go to the Supreme Court and say that, look, this court had no jurisdiction to do what it did because I had filed an application for interpretation at the Supreme Court and he had gone ahead. It didn't escalate at the end to you for determination. And so sitting on the matter when there is a matter pending in the Supreme Court is wrong. We say a court no question the judgment and determine this matter before, because what court now yes as a court no ejit to mawa, it will lead to an absurdity of the in the High Court. So you can go. So there are many avenues. You can also appeal against that at the Court of Appeal.
I see. And yeah, Mamina was a pana mimusa say, and go for 6 oh yeah appeal and as a bibi banasa will call appeal. Won't mean fa any additional evidence bi e ma na obi so be kan se bia me client no ebra ye bua ne fo no na sa enema discoveries bi e mai eno na ba sa na se me ko appeal a asebia counsel for the defense no dia na metumi ayo
appeal is an appeal on the record.
Appeal on the record.
Yes. So, your case now, and if you look at the record, judge, it doesn't support the decision of the court below. So you are looking at the record. Until appeal, they must do the record. They must settle the record, a transmitted record, not to a court of appeal. But you see, what we call to the court of appeal and say that, look, new evidence has come. Which new evidence was not available to accused person at the time of the hearing. After diligent search, but that has come. And if that new evidence were available at the court of high court, a court below, the decision would have been different. It would have affected the decision one way or the other. Because it's a court of justice. And if they are satisfied that at the time, or even convince them, the case no cause no, that matter was not available to you after a diligent search, the court will say, go back to the court of high court and reopen the matter to hear the matter. So the court will direct the high court to reopen the matter.
Papa bi amasema ba court na ye ni amame na ekire no mi ko we mu no me pesa me ko appeal based on it say in respect of maybe procedural breaches ana se bia ma ba be hwe evidence decree no mu me hu se niam bi wo mu kra na here say but the court admitted it into evidence no me ade ade a eno me ye dey metimi dia kamasam no ho bra me ko appeal.
Procedural breaches are a part of the rule of law. You see, there was substantive law and there was procedural law. The law no see men ya adi, or the law no see ya adi, uya adi ya nya. The way you must do it. The court will say, oh, case no, there is all the alternate pattern. You must hear the other side, and now I deny the other side a hearing. You have breached the rules of natural justice. So procedurally, you must hear the other side of the case, unless the other side makes it impossible to be heard. So procedural law and substantive law are the two legs of rule of law. So into one deep procedure nature, it can affect the decision on appeal. If that procedure, if not following that procedure, will result in a miscarriage of justice.
Okay.
101.7.
Nani council dia enkomo ye dia no pɛ de what wa mompa ye so obenya asem wo court.
No. That's why we are trained lawyers. That's why you're trained lawyers. So a lawyer there, you have a fiduciary responsibility to your clients. You see, you represent the interests of your friends. Okay, and then you must make sure that you do that honestly, in a way that will meet the legitimate expectations of your clients. But there must also be ethical considerations. Say, you must tell that person that why you born it. But what I will do for you, and say, I will try to mitigate your sentence. You must be honest to your client.
You see, Alaji Meda was saying, I'm pay.
And that's it.
By a mono so about would you what to announce how the old triumph I be more.
Then,
a mono about
a mono.
I new ones and make a yam, new ones, and I'm what to now buy. I'm comfort.
I don't see new yams now.
Hey, I don't want to be a banker. One yes, I know.
No, my mother is a Tendana. And we the Tendambers, my mother's side, we don't see new yam until we have pacified the gods.
Wow.
So there will have to be a yam festival.
Yam festival, yes.
Yeah, so that it can be legit for me to see it and eat it.
Wow.
Yeah, so I don't see it. Even if I see it in town, I will deny that I was in the
yeah. So that's it.
That's it.
So that's pa Honorable Alhaji Inusa Fusaini, former MP for Tamale Central.
So I was winning and some course so our political highway so Samuel AttaAkyea NHS ni secret letter na shekukwem no Kevin Taylor atwea pie e de amaya yen so ye de mu nsem ebrem ye bedamase samo je pene kokoti sa ensem we e de mai aha gossip politics TV so